Okay, this is part 2 of the HRA revision video. I apologize for the fact that it's in two parts, but as you probably heard in the first video on the HRA, my dog was acting up. I explained in the first video, the rule of law video, that, and I apologize for this, that all these videos are being done maybe slightly unprofessionally because we are forced to do it from home, right? We can't do this on campus, or we can't do it in any other place because in Malaysia we are now under a restricted movement order, which simply means that we cannot leave the house. We need to just stay at home, and so all of us are working from home, and so these disturbances are bound to happen. I will try to ensure that it is kept to a minimum, right? So my apologies for that, but let's continue, right? So I believe we were talking about section 4. We've already gone into why section 4 is good, but the problem with section 4 is that number one, as stated in section 4 sub 6, the continuing effectiveness, validity and operation of that act of parliament that was just declared incompatible is not affected at all, right? Meaning that act can still continue to cause the damage that it was causing prior to the declaration of incompatibility. It could. Secondly, if you read 4 sub 6, 4 sub 6 also clearly says that it is not binding on the two parties present in the court. And the two parties are usually the claimant, or not usually, will be the claimant and the government, isn't it? But the DOI is clearly provided for in section 4 to be not binding on the parties, which means that if the government decides that it does not want to do anything as a result of a DOI, it can. If Parliament does not want to do anything as a result of the DOI, it can, right? And this is a problem. So if the question is asking, is the Human Rights Act a guarantee of rights, then perhaps this is something you must say that it is not a guarantee, right? It clearly is not a guarantee, because a guarantee implies that the government has no choice but to comply. Here, the statute clearly says that the government has a choice. In fact, the statute clearly says that the offending legislation is not effective and it is not binding. Right, so that is going to be a problem when it comes to section 4, right? Okay, very quickly moving on. Once again, I know you can hear my dog, but we just have to make the best of it. Right, section 6, right? Let's talk about section 6. Section 6 makes it unlawful for public authority to act in a manner that is in contravention of the convention rights. Now, why is this a good thing? Once again, for the first time, there is clear statutory provision that if the government or a public authority acts in a particular way that goes against the ECHR, it is unlawful. This is good, right? This adds bite to the statute, because it clearly says that the statute, that the act of the public authority will be unlawful, right? And also, the definition of public authority includes the courts. So that's another good point to note, right? The courts will also be included in this definition. So if the courts refuse for some reason to not give you a remedy that they were supposed to give you, or the courts choose to take away your rights in any way, they will come under the definition of a public authority. So great. Tell the examiner this is good. Tell the examiner this is something that is how the Human Rights Act is actually a good thing in the process of protecting the rights of the citizen. But Section 6 is also problematic, the definition of public authority. That's the problem. The definition of public authority is not an ownership test, it's a functions test. What does this mean? A functions test simply means that it doesn't matter whether that the department or that organization is owned by the government. That does not make it a public authority. That alone doesn't make it a public authority. It also, the definition of what a public authority is will depend on the function of that organization. So even if it's a privately owned organization, but if it exercises a public function, it will then be a public authority, right? Now, in theory, this is a good thing. Why? Because now we can catch private companies as well, right? We can catch private companies as well if they are number one, exercising a public function, and then they are breaching or they are going against the ECHR. Good thing, good thing. The problem is, because this definition is a bit vague in its sense, like it's a functions test and all of that, it has given rise to situations where genuine public authorities have been able to avoid their obligation under the ECHR. A good example of that are the two cases I've given you, YL versus Birmingham City Council. If you take a look at that case, the issue here was with regard to the Birmingham City Council. Now, anyone, just with the passing understanding of law, if you look at Birmingham City Council, you would think that it is a public authority. But for the specific issue that was in dispute in this particular case, the courts held that the Birmingham City Council was not a public authority. So this is a problem, right? This is a problem. And the second major problem is that Parliament is not included in the definition of a public authority. This is obviously because to uphold the principles of parliamentary supremacy. But in terms of protection of rights, this is a problem, isn't it? All right? The reason is because now it would seem that Parliament is still free to make or unmake any laws that go against the protection of rights. Parliament can take away any rights that Parliament wants expressly, and obviously Parliament can repeal the HRA at any point as well. So Parliament, it does not come under the definition of a public authority. That is expressly provided for. That's going to be a downside. And if that is the case, once again, ladies and gentlemen, I know I'm repeating myself, but I think it's important to impress that, once again, if you are asking, is the HRA a guarantee of rights for the citizen? It can't be a guarantee. It's great. It has protected rights. It has benefited a lot of people. But is it a guarantee? No. Why? Because Parliament still can legislate any which way it wants. Section 8 next, very quickly. Section 8 talks about remedies, right? So immediately Section 8 is good. Why is Section 8 good? Because Section 8 provides for a remedy, right? In any good bill of rights or whatever that protects the rights of the citizen, there must be a provision for a remedy. If your rights have been taken away, there must be a provision for a remedy. And Section 8 is such a, provides for a remedy. So that's a good thing. But on deeper inspection of Section 8, as you can see, I've written there, on a closer inspection, the problem with Section 8 is that it says that the court may order such a relief or remedy or make such order within its jurisdiction as it considers just and appropriate. Two problems there. Number one, may order, not must order, but may order. And number two, it can only grant an order that is within its jurisdiction. right, that is within its jurisdiction. Now, who can define the jurisdiction of the courts? Arguably Parliament. Parliament can pass a law to say that, look, the courts cannot make a judgment on this particular area, and that would be that. So this is another problem with Section 8. Also, I suppose it's worth saying that Section 8 is not an equal to Article 13 of the ECHR. Article 13 of the ECHR was very conveniently not incorporated into the HRA by the government. Why? Because Article 13 is a guarantee of a remedy. Right? Article 13 is a guarantee of a remedy. Section 8 is not a guarantee of a remedy. So once again, ladies and gentlemen, if the question is saying, is the HRA a guarantee of your rights? I think it falls short. Now, don't write as if the HRA is a huge and humongous failure. That's not what I'm saying, right? That's not at all the tone in which I think the HRA is a huge success. But I'm just saying that it's got its flaws, number one. And I'm picking at the question. The 2019 question was a guarantee. And my understanding of the word guarantee means that there must be certain higher level protections that the HRA does not give. Right? So after Section 8, then very quickly I talk about Section 10 and Section 19. Right? So Section 10 and Section 19 are, if you have the time, you should talk about it. Section 10, nothing bad about Section 10. It's all good. Section 19 is a statement of compatibility. Very good. But the problem is Section 19 also allows the minister to make a statement of incompatibility. So even if the Act of Parliament is, even if the government knows that the Act of Parliament is incompatible, the government can just say, we know this is incompatible, but we want it passed anyway. So ladies and gentlemen, what we've done here is that we have taken a section by section analysis of the HRA, and then we have said that, look, the HRA has got a huge amount of, its own flaws, right? But on any normal question like what we're looking at, if they're asking you, should the HRA be replaced? I will tell you that no, it doesn't need to be replaced. It's doing a good job. It's got some problems for sure, yes. It is not as good as a Bill of Rights, let's say, that the Americans have. It's not as good as any constitutional protection that may be there in another country with a written constitution. So if you were to repeal the HRA in order to have a Bill of Rights, and that Bill of Rights can have this kind of protection, great. Then yes, I will recommend that the HRA be, let's say, replaced with a Bill of Rights. But ladies and gentlemen, as long as parliamentary supremacy is a feature of the UK Constitution, just because you call something a Bill of Rights, the same problems that exist in the HRA will continue to plague a Bill of Rights. So even just because you call it something else doesn't make it better, as long as parliamentary supremacy is a feature of the UK Constitution, right? So in this, the 2019 question that we're looking at as well, I will say that the HRA is great, but it is not a guarantee of rights because of the various flaws that we have looked at. It's not a guarantee. But the only way in which there can be a guarantee is if Parliament is no longer supreme in the UK. So putting that into perspective, it is my opinion then that unless Parliament is no longer supreme, nothing is going to give you that guarantee. So the Human Rights Act works. The Human Rights Act is something that that is working, that is helped, that has brought the protection of rights in the UK to a much higher footing, and it's doing a good job. That would be my analysis, my conclusion. Is it a guarantee? No. But given the same circumstances, if nothing else changes in the UK, nothing can be a guarantee. Right? Even the HRA can be repealed at any time. In fact, the current government, the Conservative government, have stated clearly that they want to repeal the HRA. Right? It's just that Brexit has kept them busy, right? But it can happen, right? Now, if the question then is asking for a specific Section 3, Section 4 type question, right, then please only write about Section 3, Section 4, the relationship between the courts and Parliament. So then, in that case, you need to write a little bit more about just Section 3 and Section 4, right? Now, the way I would start off by explaining what exactly Section 3 and Section 4 is. And a lot of that you can get from this answer, right? The question then will be, is there a balance of powers between Section 3 and Section 4? Does Section 3 today give too much power to the judiciary that was never envisaged by Parliament when Parliament was enacting the HRA? Right? So when we take a look at cases like Gaiden against Mendoza, that would be an important case to talk about for Section 3, and also Crown brackets Wilkinson versus the IRC. That's an important case as well to talk about. These two cases pretty much say that even the judiciary is not fully in agreement as to when you can or when you should use Section 3, right? But let's say in the case of Gaiden against Mendoza, right? In the case of Gaiden against Mendoza, it is clear that the courts seem to be telling us that the courts have to analyze the words of the statute, take a look at the words of the statute, see whether the words of the statute is compatible. If it is not, see whether you can interpret the words to make it compatible, right? To make it compatible. And this is something that judges can do. Judges don't have to be embarrassed, or judges don't have to hide and do. This is what the judiciary has told us in the case of Gaiden against Mendoza. There are limitations though. There are two limitations, right? It is not possible to give words meanings that are incompatible with the underlying thrust of the legislation, or to go against the grain of the legislation. So, look, if the entire piece of legislation is clearly to take away your privacy, let's say, for example, you can't interpret something to mean that it restores your privacy. That can't be done, right? And it is not possible for the courts to make decisions for which they are not equipped. This was stated in Gaiden against Mendoza. That simply means that the court shouldn't be making political decisions. The court shouldn't be getting into the role of giving people rights that Parliament never intended them to give. So, Gaiden against Mendoza, ladies and gentlemen, is a case that you must get into in detail. Remember, this is for those 3 and 4, Section 3 and Section 4 specific type questions, right? Get into Gaiden against Mendoza, come up with the conclusions that I have given you. Then you ask the question, does this now mean that the courts can pretty much do whatever they want? Does this now mean that the courts can depart from the clear meaning of a statute whenever they feel that it is right? Now, in the case of R brackets Wilkinson versus the IRC, 2005, right? R brackets Wilkinson versus the IRC, 2005, it was held no. If the statute is clear and the statute repeatedly says that Parliament wants something a particular way, the judiciary is not able to interpret away from it. So So the intentions of Parliament is still important. It is not that the judiciary today can ignore what Parliament intended. Parliament is still supreme, right? And the judiciary does have more power than it used to have, for sure. And this is something you can comment. Section 3 does give the judiciary far more powers than its traditional powers that it used to have. But it is still not to say that they can ignore Parliament. I think that's the point to make. Okay, then how does Section 3 then connect with Section 4? So when you cannot interpret, if it falls within one of the situations where the judge feels that he cannot interpret it to make it compatible, like a Wilkinson type situation, right? Then he will use Section 4. And he will use Section 4 and make a declaration of incompatibility. That is the power of Section 4 today, right? He will make a declaration of compatibility. Now, a very interesting case in 2018, right? R. Steinfeld and Caden. I repeat, R. Steinfeld and Caden versus Secretary of State for International Development, right? In substitution for the Home Secretary and the Education Secretary. Now, this particular case, right? It's a very cheeky case, I think. The case here was someone brought an action to say that it is unfair that heterosexual couples cannot enter into a civil partnership. If you remember, a civil partnership is something that was designed for homosexual partners to formalize their relationship. This was before homosexual partners could get married. So there was a period where what they could do was a civil partnership. Now, the Civil Partnership Act is still around, but it's only for gay couples. So a heterosexual couple has challenged that, saying that it is discrimination that a heterosexual couple is not able to get into a civil partnership, right? It's not able to get into a civil partnership. In this particular case, right, what happened? And I'm reading all of this from the textbook, right, the SUAS textbook. So please make sure you get this case, or you can just Google these cases, and you can get the substance of it, right? So in this particular case, it was held that they didn't make the declaration of incompatibility. The declaration of incompatibility was made, right, despite the government agreeing to an amendment to change the Civil Partnership Act. So the judges here made a declaration of incompatibility, even though they knew that the government was about to amend the law, or at least study the amendment of the law. And this is quite controversial, right? Because in an earlier case, a case of R on the application of Nicklinson versus the Ministry of Justice, Nicklinson, Nicklinson, right? In the Nicklinson case, many judges there were of the opinion that a declaration of incompatibility should only be done if Parliament has indicated that Parliament is not going to do anything about it, right? It was a very divided case. Nicklinson was a very, very divided case, right? Two of the judges, Lady Hale and Lord Kerr, said that they would declare incompatibility in any circumstances, right? The majority said that it was within the competence of the courts to declare incompatibility, but they should only do so in certain situations, meaning in situations where Parliament has decided that Parliament will not make any changes, right? So the majority cases were saying, the majority of the judgment effectively said that if Parliament hasn't looked at that issue yet, the court shouldn't declare incompatibility. The courts should allow Parliament to look at the issue, and if Parliament then chooses not to look at the issue, then the courts will declare incompatibility. That was the majority judgment. But if you take a look at the 2018 case that I just told you, this Steinfeld and Caden, even though, ladies and gentlemen, even though Parliament said that it was looking into amending the Civil Partnership Act, the courts courts issued a declaration of incompatibility. Now, is that too much power in the hands of the courts? Right? Baroness Hale and a few other more progressive judges, Lady Hale, Lord Kerr, they are of the opinion that the courts shouldn't be afraid of making a declaration of incompatibility. It's no big deal. Declaration of incompatibility should be made as of right. Anytime it is slightly, or anytime it is not in compliance, a statute is not in compliance with the ECHR, the court should make a declaration of incompatibility, no problems. Why? Because a declaration of incompatibility is simply the courts telling Parliament, this is wrong, change it. So it creates this dialogue. So this is what we call the dialogic model. Section 3 and Section 4 is actually, what they've done is created this dialogue between the courts and Parliament, in that now that the courts will just be able to tell Parliament this is not quite right, and Parliament will be able to fix it. So it is not a case that the courts have usurped the role of Parliament. It is not a case of Parliament overwhelming the courts, because there seems to be, over the many years, the direction of Section 3 and Section 4 seems to be a very nice balance between the courts and Parliament, and this has created a dialogue between the courts and Parliament, and this is good. This is good, right? That would be how you would approach one of those very specific Section 3 and Section 4 type questions, right? Okay, I hope these sessions have been useful. This is the end for the Human Rights Act revision, right? Thank you.